Good morning, Your Honors. The matter before the court this morning is the case entitled Mary Lynn Johnson et al. Versus Agency of Transportation, case number 23 AP 249. Appellant Galloway C. Morris is self-represented and is appearing by phone. Representing the appellee, Agency of Transportation, is attorney Mark A. Seltzer.
All right, and the appellant, please introduce yourself and you may proceed.
Good morning. My name is Galloway C. Morris. I'm contesting a procedure which AOT initiated and executed in 2020.
All right, we'll ask
That
you to
is,
speak up if you could, Mr. Morris.
Right, I'll hold the phone closer. That procedure was what's characterized as a statutory survey per Title 19, subsection 33. And what that did was it altered the right-of-way boundaries of a 1.5-mile strip on Route 2 between the Richmond exit and the village of Richmond itself. I live in that strip. What that did was, what AOT did following their survey was they filed it with the town clerk, which effectively established control of a 4-rod right-of-way as opposed to the 3-rod right-of-way, which it was for many decades. The reason it was a 3-rod wide road for many decades was that the road originated as the Winooski Turnpike, and a survey in 1811 was reputedly filed with the town clerk stating that it was laid out as 4 rods wide in 1812. However, there was no document found in recent history at the town clerk, nor anywhere else until, perhaps 15 years ago. In the collections of the UVM library, a surveyor from the 1850s filed a copy of this survey dated 1837.
Mr. Galloway, this is
Yes.
Justice Carroll. I'm going to ask you a question. There were a lot of plaintiffs here, and this is based on a motion for summary judgment. Were you given the motion? Were you copied on that motion for summary judgment, and did you participate in that process?
No, I didn't. So what happened almost 4 years ago now was all 13 of the residents abutting Route 2 in this location filed a separate appeal to Superior Court in Chittenden County. The judge that was reviewing each of those had a conference meeting with us and said that he was inclined to aggregate all 13 parties. I, at that time, expressed that I had no interest in that, and I thought that my case would be lessened if it were aggregated with the others. However,
Appellant, 1 minute remaining.
I understand that they did aggregate it, and I got a record of that.
Yeah, I really want to hear, I really, because you don't have much time yet, I just really want to hear about the motion for summary judgment and whether you received that and when you became, if you did, aware of that.
I became aware of that weeks after the final judgment ruling came out. Because what happened is during that aggregation, the court lost my case. So they may have aggregated 12 and not 13, but following that, I didn't get information. I was notified by neighbors that there was mediation also ordered, but following that mediation, which I attended on August 12th, 2022, I received
Appellant,
nothing.
no time remaining.
I
Mr.
received
Morris,
nothing
please
until
follow up with
after.
that and then conclude.
I received nothing until after the final ruling came out. So I had no opportunity to submit any evidence. I had no idea what evidence had been submitted. I don't know what I didn't at that time know what the judge considered for her ruling.
All right, and we'll have to leave it there, sir. Thank you.
Oh, let me just say that I called the court, your court, asking how to appeal because I was under this understanding that I would appeal with you, and your administrator had me appeal through the Superior Court. So
All
this
right.
is the only avenue that I'm aware of to appeal.
Thank you, sir. Your time is up. We will consider your arguments. Does the appellee wish to
Will
be
you
heard?
consider my briefs?
Does the appellee wish to be heard?
Will you consider my briefs?
All right, sir. Yes, we will consider what you have submitted, and thank you for your argument.
Good morning, Your Honors.
I didn't make an argument, but okay.
Thank you, sir. Counsel, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Mark Seltzer, and I represent the appellee, State of Vermont Agency of Transportation. The issue before the Court today is whether the Court, in reviewing the matter de novo, should affirm the trial court's finding that the agency correctly conducted a road survey finding a right-of-way width of at least 4 rods or 66 feet wide along Route 2 in Richmond, Vermont. The Court should affirm summary judgment for the following reasons. The agency served notices, motions, and briefs of Mr. Morris and other litigants. The preserved 1812 road survey established the Route 2 Winooski Turnpike as 4 rods wide. Available evidence, including use patterns, supports the agency's findings of 4 rods wide, and new arguments raised by appellant are not admissible on appeal. Going into the first argument on the service, while the agency cannot speak for the court on what happened at the trial court level, the agency did provide service to Mr. Morris for summary judgment practice, depositions, etc. During the process at the trial court level. The agency is aware of the consolidation effort for Mr. Morris's docket and is aware that in his docket there was a consolidation note indicating it would be consolidated with Ms. Johnson's docket. The 1812 road survey establishing the Winooski Turnpike was preserved and recorded. As Mr. Morris articulated, it was found in the John Johnson collection and the UVM special collections. Mr. Johnson was a road surveyor for the state, and a copy was preserved there. Mr. Morris is correct that there is the last page of volume 1 and 2 where the survey would have been located is no longer there in the books, but a copy has been preserved properly in the John Johnson collection, and it's been recorded based on the note on the top of the survey in the John Johnson collection, as well as the notation in the index to volume 1 and 2 of the Richmond Land Records.
So if I understand correctly, there's an indication in the Richmond Land Records that it was recorded, but it's not in the Richmond Land Records. And there was a copy located that was recorded or filed some 25 years later in the reports at the UVM library. Is that correct?
I don't know about filed, but it was located there. So It's been preserved in the UVM library. We were able to locate a copy in the John Johnson Special Collection, and there's a notation on the bottom of the index page showing what page number the survey would have been filed in the Richmond Land Record. It was on the
But
last page
this
of
was
the book.
apparently in 1837. It arrived at UVM. Is that right?
That sounds accurate, Your Honor. And that's when the collection was turned over to the UVM from John Johnson's heirs, is my understanding. In addition to the recording, the note that it was recorded in the top of the copy that was in the John Johnson collection and the index, what the agency does is it looks at all evidence it has in its possession that it can look at. These include monuments on the ground, use patterns, as well as deeds of other individuals where they may have done a survey of land to figure out what the road width would be. Through all the evidence we looked at, following the footsteps.
Appellee, 1 minute remaining.
Thank you. Following the footsteps, we determined that the width was accurately 4 rods wide, and that's why that was recorded in the land record. Appellant raised a number of new arguments in its appellate brief. These arguments are both unfounded as well as not pertinent to this case because they weren't raised at the trial court level. For the following reasons the reasons that were discussed earlier, this court should affirm summary judgment for the Agency of Transportation, finding that Route 2 in Richmond, Vermont is 4 rods wide. Thank you, Your Honors.
All right. Any questions for counsel?
I'm all set.
All right. The appellant has no time remaining. We will consider the materials and arguments properly before the court and we'll render a decision shortly. Thank you both very much.
Thank you.
And bailiff, you may call the conclusion of the hearing.